Hello, back again for episode 3. I got the PowerPoint going, so I'm pretty excited about that. I don't know, it's gonna be nothing special, but like I said in the last one, I kind of went crazy with the MS Paint, so hopefully it'll at least help me explain some of these answers a little better. And it was also just kind of fun going through the process and kind of drawing some of that stuff out and making it into a good models at least, or a basic model to help explain some of this stuff. And yeah, so the exam now is about 6 days out, next Thursday. So preparation I think's been going pretty well. Like I said in the last one, it was a matter of making it a lot more making my answers more concise and getting them down to a more manageable level, especially with the working within the time constraints of the exam. So yeah, that's what I've been kind of doing. There was a study. We had a group study session yesterday with for the class, and that helped too. Felt kind of reassured on some answers, and then answered some questions in some other places. So feeling decent about it. I think I still got a ways to go. I definitely want to lock some of this stuff in, and it's gonna be a tough. I mean, yeah, it's gonna be a tough exam, no doubt about it. And just trying to make sure to put forth the best answer possible is gonna be key. And like I said, just getting some of this stuff down as well as can. Um, Comments about the last video. Audio is better. Yeah, so I'm standing in a better spot. I like I said in the first one, I was standing way too close to the whatever. The mic wasn't picking me up very well, so scooted back a bit. Hopefully, I am a little bit off to the side this time with the PowerPoint, so hopefully it's still picking me up good. Looks like it is, so that's good. But yeah, I guess I'm not gonna beat around the bush too much here. I don't got much else to say. I guess I from PowerPoint, so that'll help with a couple of the questions explaining some of my answers. And I'd like to do one more video at least before the exam, and I'm gonna try to do it as much next one as much as possible without the answers written in, just the questions, and see if I can go from there and see how well I do, because I think that's kind of key, is just being able to answer these questions. Going to be able to answer them from memory, especially when it gets into more of the specifics with some of the cases and yeah, the grants and acts and policies and stuff. So yeah, anyway, I guess I'll just get started and yeah, try to incorporate the slideshow as much as possible this time. And like I said, in the first one, this is pretty much just made for myself to study with, but if anyone else happens upon it, I hope the slideshow helps a bit. Yeah, I did make these slides myself on Paint, but they are, I mean, I definitely pulled from cases and from class materials and book materials to make them. So I'll definitely, in the description, I'll have the textbook, as well as just mentioning the class and yeah, stuff like that, just where you might be able to find some more information if you're interested, or if you're studying for the same exam, where you can find this information. Because yeah. Anyway, all right, I'll get started. All right. Question number 1: briefly describe 2 ways in which federal lands were historically disposed. How does the history of federal land disposition and retention help explain the crazy quilt of land ownership patterns in parts of Montana and the American West? So first, one way that land was disposed from the federal government was through land grants to settlers. There was a series of homestead acts that would lead to an eventual 285 million acres being disposed to settlers across the West, across the Midwest, East even. And these homestead acts allowed for people to claim lands for either for free with the payment of payment of a fee, and also meeting certain stipulations before they could claim that patent. And then there was lands that were just sold as well to settlers at a price per acre. And then the second one I go with here is land grants to railroads, as railroads, or to encourage railroads expansion across America. The United States government was issuing land grants to the railroads, and they would, yeah, like I've stated in the past, they give out those alternate sections from the railroad within a certain perimeter along the railroad. And I got a slide coming up here too that'll allow me to explain it a little bit better and a little easier. But essentially, yeah, so they'd give the railroad a section or a swath of land, and within that swath of land, on either side of where the railroad itself is constructed, the railroad would receive alternate sections of land. The federal government would then retain the sections within those alternate sections of land, in the theory that that federal land that is retained would be increased in value by the railroad construction. And then this plays into the Jeffersonian survey system, which was adopted by the U.S. through the General Land Ordinance of 1785, which established that all lands in the United States would be surveyed, and under the Jeffersonian rectangular survey system, which I'll actually do. Okay, so here we kind of got an example of the Jeffersonian survey system. It's apologies for the crudeness of this model. It's not to scale, but it is. This is it's so you got each section is 1 square mile or 640 acres, and it's going to be 6 by 6 or 36 sections makes a township. So this would be a township, and that's how they were gonna, after the General Land Ordinance of 1785, they'd be surveying lands across the United States in this format, and so that also plays into how these lands were distributed, because then like settlers, homesteaders, I believe it was the Homestead Act of 1862, signed into law by Lincoln. But that would grant 160 acres to a homesteader, and someone who was either head of a family or over 21 years of age, that was a citizen or had intent to become a citizen, could claim 160. So it would be a quarter section. That's one example. And then going forward, I have also the railroad grants. So briefly help explain the crazy quilt of land ownership patterns in parts of the American West. So as the U.S. shifts out of this disposition era and into the retention era, especially with those railroad grants, you got these retained federal lands intermixed with these I think the biggest contributor to this crazy quilt would be the railroad grants, especially because it gave those alternate sections of land with the federal lands intermixed with it. And yet that is definitely, contributes to that mosaic of public and private lands. And I think I also have a slide of that as well to kind of help. Here we go. Yeah. And I think I'll come back to this one. Yeah, okay, I guess I'll kind of do that in the next one as well. But here's an example of one of the railroad grants that I made up here. So here we got this. Like I said, not to scale, apologies for the crudeness of the model, but here we got a railroad coming down the middle of this township, and then here we can see the blue would be the federal public land, the reds are the land that the federal government granted to the railroad in order, for the building of the railroad. So, we got these alternate sections, checkerboarded alternate sections. So we got public, private, and these are each 1 mile. So this is just 3 miles here, and depending on what land grant to railroads it would either be, it could be 10 miles, it could be 20 miles, or it could even be 40 miles in the case of I can't remember which one it was, but there was that was only limited to railroads built in territories, but still, just imagine, this is going to extend on for 40 miles of this checkerboard landscape, and that's going to be on each side. So in total, it's going to be 80 miles, an 80-mile swath of this checkerboarded, and that's also, it'll come up in a further question here, but these public lands that are completely surrounded by private would be referred to as landlocked. The only way you could access this is through this corner here. There's no roads, and you can't get through, if this is private land, you're not going to be able to cut through it. And I think I've kind of gone off topic for first question here, getting distracted with the PowerPoint, but just trying to set the scene a little bit for how this crazy quilt of land ownership was established. All right, I'm going to roll on to question 2 here, and I've kind of answered this a bit already, but how does the history of railroad land grants and the Unlawful Enclosures Act of 1885 help us to understand the 2 parts of the contemporary disputes about corner crossing and landlocked public lands. So, like I've stated before, those land grants would give out these alternate sections within a certain perimeter of the railroad itself. So that's how you ended up with those landlocked sections of public land. And, I guess, I even got a little bit of thing there. 99.52 million acres today of this landlocked land. So that's how you end up with those landlocked sections. And that's like I said, continued on into today. Landowners, private, the railroads have sold this land, and the public, the federal government has retained that public land through, like the Taylor Grazing Act or the 2 executive orders from FDR, and then FLIPMA in 1976, which established that all public lands would, from there on, be retained and could no longer be settled or sold, given there's certain circumstances where it might be exchanged. But so how does this help us to understand the two? Oh, and then there's the Unlawful Enclosures Act. So that the Unlawful Enclosures Acts, an Unlawful Enclosure Act of 1885, pretty much established that individuals, no one can either like fence or obstruct or prevent someone from entering public domain, even through like threat of violence or threat just in general. They can't prevent someone from entering or crossing over federal public lands. And so that's where it gets kind of tough though with corner crossing, because under the with the Unlawful Enclosures Act, there's not a private individual that lives on this land, that owns this land, can't physically prevent someone from, like, they couldn't build a fence here or prevent someone from crossing into that. But at the same time, corner crossing it's not legal, and like it depends from state to state the legality of corner crossing, because by corner crossing you are still going to pass through the airspace of this private landowner's land here. So those are like kind of the two factors that have led to these contemporary disputes today. And I even also got, and that Campfield versus U.S. case is really, that's front and center about the Unlawful Enclosure Act. And I do have a slide for that one as well. So here we can see kind of just how the Campfield versus U.S. case played out. And this was a, big example of the Unlawful Enclosure Act. So I don't have and like this is not to scale, but there was a private landowner or private group of private landowners that had, they owned the rights to these private lands here, and here. So they constructed a fence illustrated by the green, and the fence was only on private land, but effectively prevented anyone from entering this public land here. And therefore, that was, it was taken to court, and they through the Unlawful Enclosure Act, under the Property Clause of the U.S. Constitution, they found, they deemed this was illegal. He couldn't do this. He couldn't close off this public land for his sole use of grazing. And that's kind of one example of the Unlawful Enclosures Act in work, and also at least, kind of still, shows how this checkerboarded landscape has contributed to disputes. And this is even an old case, more recent case would be the Iron Bar Holdings v. Cape, Wyoming corner crossing case. Really prominent the past couple of years, but also, corner crossing as a result of this checkerboarded landscape. A lot of trouble there. I'm going to flick it back a couple slides to the railroad one. But, okay. So moving on to the next one. Briefly stated, what is a checkerboard landscape and how did it happen? Provide one example of a management issue or challenge associated with checkerboards. So, like I stated, in the past couple, a checkerboard landscape is made up of alternating sections of private and public land, or private and public federal lands. Sections of public federal land may only be accessible diagonally via the corners and is therefore landlocked. These landscapes came out of the disposition era, and in particular the the railroad grants. There were also the state grants, which would give sections to states, but it was I think the biggest contributor to that checkerboarded landscape would definitely have to be the railroad grants, but the state land grants to a certain extent outside of the swaths of railroad grants. And yeah, I guess a management issue that's arisen out of this, like I've kind of established in the past couple, would be accessing these landlocked public lands for, management or recreation. It's because if that land's landlocked and there's no road or any easement of any sort, the only way you could access it is cutting diagonally and corner crossing, which, depending from state to state, is illegal. But but you can't enclose it and prevent someone from entering it either under the Unlawful Enclosure Act. Okay, moving on. So for what purposes are state trust lands to be managed? State trust lands are to be managed for beneficiaries to generate income for beneficiaries by the state. These beneficiaries are typically schools or other public institutions. For what purpose are state trust lands to be managed, and how did states come to own this land, and how is it generally distributed? What is the most common and significant beneficiary of state trust land management? So like I said in the last ones, state trust lands are to be managed to generate revenue for beneficiaries, which, I guess I'll finish off the question with that part. But how did states come to own this land, and how is it generally distributed? Lots of states came into ownership of this land via states enabling acts, and then there was also the Northwest Ordinance of 1787, which laid out kind of how new states would enter the Union, and especially, at the time it had only been written in specifically for that area to the north and west of the Ohio River, so like Ohio, Illinois, Michigan, Wisconsin, and then part of Minnesota. And it laid out that those states would enter it laid out how those states would get entered into the Union. A lot of these states, as they entered the Union via enabling acts from Congress, these enabling acts would give they'd provide states with federal land, or at least they'd give states a little bit of federal land. And like I said, in order to generate revenue for beneficiaries, because these states wouldn't be allowed to collect taxes, or revenue from the federal lands that were still retained within the state borders. So the government gives these states some federal land when they're brought into the Union. And the precedent started with Ohio in 1803, where Ohio was granted one section per township. And I do got a slide for this as well. Okay, so here we go. So here we got. This is kind of an example of how those lands would be given out. But Ohio sets the precedent in 1803, one section per township. And then over time, the number of sections per township would increase. In California, 1850, it bumps up to 2 sections per township. And then starting with Utah in 1896, it's up to 4. And then even later down as it continues, states are also getting more land outside of these townships. So like Arizona, I think ended up with 14% of its total land area in this enabling act land grants to states. And like I said, that land was to be managed to generate revenue for beneficiaries, which was schools and other public institutions. I think with Arizona, when I was reading the book, it said it was like an insane asylum, a school for the deaf, dumb, and blind, which a product of the time. So but anyways, and here's an example. Here we got, so here's a township, and so for like Ohio's case, they would have just received section 16 for every township as their trust, in their enabling act. And then as time goes on, with California was getting 16 and 36 per township, and then eventually with Utah in 1896, they were getting 2, 16, 32, and 36 per township. So they were getting, it was incrementally increasing. And you can see how this would also contribute to that crazy quilt we were talking about earlier. Once you get away from the railroad grants, and you get further, like I said, further away from the railroad grants, then you have this also. You got these sections of federal land given to the state intermixed within, and then you also might have settlers, homesteads possibly in here too, intermixed with these state lands. So kind of building off the previous few questions. Let's see, where am I? Okay. What is the most common and significant beneficiary of state trust lands? They're, the schools. Schools are supposed to be the most common and most significant beneficiary of state trust lands. All right. Let's see. Why is most federal public land located in the western United States? Why is so much of this federal public land intermingled with state and private property? Briefly describe one management conflict conflict or challenge that results from such intermixed ownership. I mean, from a general sense, the East and the Midwest, the climate's just a lot more favorable, right? For homesteading. It doesn't, wouldn't take near as much acreage for a farmer to support his family in Illinois or Iowa or Ohio than it would, for, say, a homesteader in Utah or eastern Montana, North Dakota, South Dakota, Arizona. That's a lot, it's a lot less forgiving landscape. It's harsher, drier, colder. So that'd be one thing. A lot of that eastern, midwestern land was claimed a lot quicker or a lot sooner. As soon as that, was made available, people were claiming it, or even before it was made available, through preemption, they got that land. So that's kind of just a general reason as to why there's a lot less land in the, public land in the East than in the West. And then, that also plays into, that unclaimed and unsettled land in the West, as we move into that, the federal retention era, it starts kind of in 1872 when you got Yellowstone National Park, the formation of that. But then moving on from that, you got the Forest Reserves Act, which passed by Congress, which allowed a president to create forest reserves of federal public land. And then you got the Antiquities Act of 1906, which also allowed presidents to preserve national monuments, archaeological sites, and stuff like that as national monuments as well. But I think more like the bigger contributors to the retention, at least from what I've gathered in the reading, was the Taylor Grazing Act of 1934, which were pretty much, I think it was 80 million acres that hadn't been settled, but it was used for grazing, but it did close it off for settlement. They still left it. They made it available for lease for grazing, but it could no longer be settled or homesteaded. And that was a lot of that, I think, was in the Southwest, where I had mentioned it was, a harder landscape to homestead anyway. But that was retained. And then following that, FDR issued 2 executive orders, which retained the remaining federal lands that hadn't been homesteaded or settled on yet. And so that pretty much, there wasn't any more federal land to be homesteaded or, to be settled on. It was still available to the public for use, but not homesteaded and claimed and made into the private hands. And then FLIPMA was passed in 1976, which stated that no more land, all the federal land would be retained. I definitely misquoted that a little bit, but essentially that's what summed it up. All the federal land that's in federal hands will be retained. So, why is so much of this federal public land intermingled with state and private property? Like I've established on the previous few and with the slides, now that you got all that land retained, it's still, you still got all this, the state trust, state enabling acts lands, trust lands. You got the homesteaded land, and then you also got the railroad grants. So now you just got all sorts of different private holdings intermixed with that federal public land that's been retained. And I guess, one management conflict that arises from this, like I said in a couple slides or a couple questions ago, is accessing that public land that could be potentially landlocked by four private holdings, and therefore, it's accessing it via the corner is controversial, and legality depends per state. And also, like I said earlier, mentioned earlier, there's the Northwest. I don't know if I need to go into that actually on this one. I feel like I kind of hammered this one home a bit. Yeah. Okay. Let's see. How does Kleppe v. New Mexico, 1976, help us to understand the powers derived from the property clause of the U.S. Constitution? What does this have to do with federal lands and wildlife management? So, through the property clause, or underneath, pursuant to the property clause, Congress wrote the Free Roaming Horses and Burros Act, and essentially, yeah. So this meant that this kind of extended the reach of the property clause to wildlife on federal land. And in Kleppe versus New Mexico, so yeah, the state of New Mexico, under the pursuant to their state estray law, took 19 burros off federal public land and sold them at auction. Farmer had claimed that they were, harassing his cattle, and I'm not here to dispute that or anything, but so he claimed that they were just, harassing his cattle. So that, the state comes in and, okay, I don't know, that was weird. Some dude just poked his head in, but anyway, keep rolling. Anyway, so state comes in pursuant to their stray law, takes the cattle and removes it, sells it at auction. Therefore, okay, now I just totally lost my train. But anyway, BLM comes in, says, "Hey, you gotta those horses back. Those are protected under the Wild and Free Roaming Horses Act, Horses and Burros Act." State of New Mexico takes them to court over it, and challenges the legality of the Free Roaming Horses and Burros Act pursuant to the property clause. Essentially, the Supreme Court finds that the Congress was acting with it. It falls within the property clause, and therefore the property clause, pursuant to the Constitution, overrides the New Mexico estray law, or the Free Roaming Horses and Burros Act overrides the New Mexico estray law. And therefore, I think I just lost it a little bit there. But anyway, in this case, and in cases where state laws and federal laws coincide in federal laws on federal lands, the state laws got to recede, and and that also gets into the supremacy clause of the Constitution a bit too. But it doesn't ask about that here. Okay, the U.S. Constitution. I don't know if that one. I don't think I answered that quite well, but I'm gonna keep moving. The U.S. Constitution's property clause, the Congress shall have the power to dispose of and make all needful rules and regulations respecting the territory or other property belonging to the United States. How does the property clause help us to understand the limitations presented to those states seeking the transfer of federal land to state ownership? Provide one example of the property clause power used by Congress and interpreted by the Supreme Court. So I am trying to answer these as much as I can without looking at the my answers here. So if I am kind of going off on little tangents and stuff, that's definitely it. But well, not just it. But anyway, so in order for a state for a state to get land, if it wanted land from the federal government, it would need Congress to approve that transfer, which is would be a pretty big undertaking in itself. And then if say Congress did approve that transfer, they're not. If it was through the FLIPMA process, the lands exchange would have to be equal value or in the public's best interest. And I think the book gives examples of the lands around, I think it's around Vegas or in Nevada at least, where the federal government and the state transfer lands, so that just to make it I think it's to avoid a wildland urban interface, or make that transition a little better, with the expanding city, transferring those lands. But Congress wouldn't need to do that. They could make it a pretty poor deal if they wanted to as well. Anyways, so what's an example of the property clause power being used by Congress and interpreted by the Supreme Court? Well, we can go back to Kleppe versus New Mexico, where they used the property clause to write the Free Roaming Horses and Burros Act, and then Supreme Court came in, and they interpreted it, and they said, that checks out. The property clause does extend to wildlife, and so the Free Roaming Horses and Burros Act is pursuant to the property clause and is therefore, legal, and then tied hand in hand with the supremacy clause, overrule the state regulation on those federal lands. What part of the U.S. Constitution provides Congress the authority to enact the Unlawful Enclosure Act of 1885? What is the basic purpose of this act? So that Unlawful Enclosure Act also falls under the property clause as well, or is pursuant to the property clause as well. The basic purpose of the UIA is to, yeah, pretty much like I stated earlier, and I can go back to the slide too from the Campfield versus U.S. case. But essentially, yeah, the or the UIA or Unlawful Enclosures Act, which I'm actually kind of wondering, like, it's referred to as the UIA, but and it's written, enclosures is spelled with an E. I don't know, but anyway, the Unlawful Enclosures Act is to prevent this pretty much from happening. Someone preventing. I mean, it wasn't written pursuant to directly after this or yeah, but it's to prevent. It makes it illegal from anyone from anyone essentially having the sole use of public land by either enclosure, threat, or yeah, just it's to prevent someone from preventing other people. It makes the act of preventing other people from accessing public land or just traveling across public land illegal. And there was also the oh dang it, the Leo Sheep case. Ooh, yeah, that's a good one too for the Unlawful Enclosures Act, where the guy was. It was a bit weird though. Like I could see why the private landowner. Maybe I'll have that one kind of locked and loaded for the next video. In a nutshell, what is the Supremacy Clause of the U.S. Constitution, and how would it help resolve a case involving a federal law conflict with a state law? So, okay, yeah, the Supremacy Clause essentially establishes that any rules, treaties, acts, anything made pursuant to the Constitution is the supreme law of the land. So, how would it help resolve a case involving a federal law in conflict with the state law? Well, we can go back to Kleppe v. New Mexico again. Essentially, with it under the Supremacy Clause, and and since the Free Roaming in Horses and Burros Act was found to be legal, pursuant to the Property Clause, the Supremacy Clause then means that Free Roaming Horses and Burros Act is going to supersede any of the New Mexico state laws, and in that case, the New Mexico Stray Law on the federal lands, and therefore it's the supreme law of the land. New Mexico's got to deal with it, and yeah, that's pretty much how those two work together. Or that's how the Supremacy Clause, at least, it's the supreme law of the land, is the federal law pursuant to the Constitution. So Article 3 of the Hellgate Treaty of 1855 governs the Confederated Salish and Kootenai tribes. It reads, "The exclusive right of taking fish in all the streams running through or bordering said reservation is further secured to said Indians, as also the right of taking fish at all usual and accustomed places in common with citizens of the territory, and of erecting temporary buildings for curing, together with the privilege of hunting, gathering roots and berries, and pasturing their horses and cattle upon open and unclaimed land." What two parts of the U.S. Constitution help us to understand the legal basis of this clause, and what does it have to do with the federal public land and/or fish and wildlife management? So the two constitutional clauses that have to do with the treaty directly would be the number one, the treaty clause, which gives the president power to make treaties with a 2/3 vote from the Senate, and then the supremacy clause, which establishes that treaties are the supreme law of the land. So in this treaty, in this language here, it gives it reserved the tribe reserved the right through this treaty to hunt and fish and to taking fish on all their streams running through and bordering their reservation, but then it also it secures the rights to privilege of hunting, gathering roots, berries, pasturing horses, cattle, and upon open and unclaimed land. So in Montana, and then in the Montana Supreme Court, I can't remember the year on this one. I want to say 76, but I feel like I've said that for several other ones, so I don't know. But anyway, the Montana Supreme Court found that all open and unclaimed land would, Forest Service land falls under that terminology. So, pursuant, made legal by the right given to the president in the treaty clause, this treaty was written, and then pursuant to the Supremacy Clause, which made this treaty the supreme law of the land, the tribal members can hunt. This means essentially like that the tribal members could hunt and or hunt or fish outside of like a Montana official seasons or outside of regulations on that Forest Service land. That's not on their not on the reservation. That's what the the treaty gives them the right to do that pursuant to the treaty clause and then the supremacy clause. How does an administrative rule or regulation differ from a statute? So a statute is written by Congress and passed into law by Congress pursuant to the Constitution, and those are codified in the U.S. Code. And then, so an administrative rule or regulation is written pursuant to those statutes written by Congress, which are pursuant to the Constitution. But the regulations, administrative rules and regulations, essentially take the ambiguity of the language in those overall statutes, those broad framework statutes, and interpret it and use their agency, use agency expertise to make management, make management more achievable and define goals and define terms. And then also with the rules and regulations, they got to be produced through the APA process and undergo judicial review before they're approved as well. And you can find the rules and regulations in the Code of Federal Regulations, the CFR. How does an administrative rule or regulation differ from a statute? Where are statutes and regulations codified? Why does rulemaking, the writing of regulations, generally happen? So, like I said in the last one, statutes are written by Congress and then pursuant to the Constitution. They're found in the U.S. Code. And then, we got the rules and regulations, which are written by executive agencies. These are pursuant to the statutes written by Congress, and they must undergo the APA Administrative Procedure Act and undergo a judicial review as well before they're codified in the Code of Federal Regulations, the CFR. Regulations are usually written kind of like I mentioned in the last one, because when Congress writes a statute, they might leave some ambiguity. They're not going to answer all the questions. They're going to leave some stuff open to interpretation and defer to that agency expertise. So that's kind of that. I mean, that's why the writing of regulations is to kind of focus in order to to fill in the gaps. As kind of one of the terms that we've used quite a bit in lecture and stuff. As discussed in class, the National Forest Management Act includes a provision related to wildlife. Forest plans shall provide for diversity of plant and animal communities based on the sustainability and capability of the specific land area in order to meet the overall multiple use objectives. Describe the general process pursuant to the Administrative Procedure Act of 1946 that was used to write the U.S. Forest Service's diversity regulations. Why were these regulations necessary? On what legal basis could the agency's regulations pertaining to diversity be challenged by outside interest? So, pursuant to the Administrative Procedure Act, the first step for an agency to make and in this case, for the Forest Service to make those diversity regulations would be to provide public notice, and this would be published in the Federal Register, and it would just kind of lay out the details of what they're looking to do on this. What's the goal here? What are we looking to do? And you're just providing public information on the act, on the action. And then second step pursuant, and it goes hand in hand with the first step, is getting the public to participate, getting public participation going. And this will also be posted. I think these would be tied in with the post for the first part with the notice, and that would provide public meeting times and how they can participate. And that's like I said, both of these will probably be found in the Federal Register when when that notice is established. And this is also why this informal rulemaking process is called notice and comment. Is they have to provide notice and allow for comment and allow for adequate public participation while in the making of these regulations. And then the third step in this process would be judicial review. So they're gonna, the courts are gonna, after we go through the notice and comment, the courts are gonna review this under the arbitrary and capricious standard, and they're gonna maybe ask, this post Chevron, but they're gonna look at it and kind of ask questions. Is there a rational connection between the facts found and the decision made by the agency? Is there a clear error in judgment by the agency? And then was there an important aspect of the problem issue that was not considered by the agency? These are just kind of a few of the questions they'll ask when determining if this is if this act or regulations would be arbitrary and capricious. Okay, and let's see. Oh, and then I guess last part of the question, on what legal basis could the agency regulations pertaining to diversity be challenged by an interest? Outside interest, they could be challenged as arbitrary and capricious. Maybe, someone doesn't see how they how they interpreted that diversity regulations to mean what they end up putting into their regulations. And they could take it to court and challenge that decision by the agency. What is the judicial review provision of the APA? What does it mean when people say this is a deferential standard of review? What does statutory ambiguity have to do with this? Does this mean that federal agencies cannot be held accountable for their actions and decisions? Please explain with a real or hypothetical example. So, like I said in the last one, the judicial review provision is essentially the courts taking a look at the decision, uh, under the arbitrary and capricious standard review. So, and like I said, they're gonna look, is there a rational connection between the facts, decision and the facts found? Um, is there a clear error in judgment by the agency, or did the agency overlook an important aspect of this problem? And so it's referred to as a deferential standard review because it's a limited inquiry that the courts are looking at this decision under. They're just looking under the arbitrary and capricious standard. They're not supplementing. The court's not supplementing their interpretation for agency expertise. So especially under Chevron, it was very deferential, and it's going to be at least. I guess it's kind of uncertain right now, but it's a limited inquiry. They're only looking if it's the agency decision was arbitrary and capricious. And how does statutory ambiguity have to do with this? So, like I said earlier, when Congress writes statutes, they're gonna leave some ambiguity and be silent, maybe not answer some leave open some big questions for the agencies to interpret and write regulations in. So it gets tough, when courts are reviewing a decision for to see if it's arbitrary and capricious. They're gonna see it, and look at the statute too, how did they get from there to there? How did they interpret this to mean that? And how did they get from there to writing this regulation? So an example, I guess this is, hold up. Does this mean that federal agencies cannot be held accountable for their actions and decisions? Please provide an example, or real or hypothetical. So we can go. In class we hit the northern spotted owl versus Hodel case pretty hard, but it's a pretty good example of this. U.S. Forest Service, despite what their biologists and their crew had, their team they'd put together for, and now analyzing the northern spotted owl populations, and they came out and said, hey, yeah, northern spotted owl, they're not doing so hot. Looks like they're imminent threat of extinction. Forest Service, or U.S. Fish and Wildlife Service, still doesn't list them. Deems that it's not worth listing at the time, and it's kind of just assert agency expertise as the reasoning why. Congress or the courts find that that's arbitrary and capricious. You guys didn't provide, you definitely didn't provide a rational connection between the decision made and the facts found, or the facts found and the decision made here. And then also, maybe they overlooked, but it was, definitely a pretty prime example where they didn't provide any analysis as to how they got their answer in that decision. Okay, briefly describe one implication that may result from a public land law that is written by Congress in a relatively vague or open-ended fashion. So this kind of gets into how the election cycle. So you have one executive, a change in the executive, essentially. So every 4 years you might get a new person in who's got a different agenda and a different way they want things to be run and organized. So you're going to have new heads of all these agencies and departments, Department of Interior, USDA, new heads coming in. It's going to be a top-down change, and they're going to, start rewriting rules and regulations, and that ambiguity in those statutes allows them to do that. So it does lend itself to a lot of uncertainty during these big pendulum swings of different executives. And also, and that's also another reason why they kind of cited in the Loper v. Bright case the reason to overturning Chevron is maybe to prevent that going forward. To prevent such an oscillation in the in the regulations when there's a change in the executive. Use northern spotted owl versus Hodel to explain the arbitrary and capricious standard of judicial review, and explain the 2 to 3 questions the court asks in determining and explain review standard of judicial review, and explain the 2 to 3 questions the court asks in determining whether an agency action is arbitrary or capricious. So, pursuant to the Endangered Species Act, U.S. Fish and Wildlife Service reviews northern spotted owl for possible listing due to, there was a lot of old growth logging going on in the Pacific Northwest, and they were, worried about the northern spotted owl population. So, experts and biologists, and even after peer review, determined the species is in threat of imminent extinction. U.S. Fish and Wildlife Service asserts own expertise, does not deem that the spotted owl is in need of listing. They didn't provide any analysis. They didn't provide how they got to that decision from the conclusions that the scientists had reached earlier. So goes to the courts. The courts review it. They can't find that rational connection between the facts found, decision made, and therefore it is ruled as arbitrary and capricious, and they got to go back. They're remanded and have to go back and do it again. And then that's kind of the first. There's the rational. Lights just came on in here. That was kind of weird, but anyway. So that's the first. The first question that the courts might ask: is there a rational connection between the facts found and the decision made? Obviously, in that case, there wasn't, or they didn't. It wasn't provided, at least, if there was. And then the second question, was there a clear error in judgment by the agency? And the third question they might ask is there an important problem or issue that was overlooked or wasn't considered by the agency? And like those two, I don't know if I haven't been really able to connect those two to the northern spotted owl versus Hodel. Like not like the first question. That's pretty easy to connect there. So anyway, put simply, 1 to 2 sentences. What was the Chevron doctrine, and how was it applied by the courts to a federal agency's interpretation of a rule or interpretation of a law in a rule and regulation. So the Chevron doctrine, also known as the Chevron two-step, previously used by courts during the judicial reviews phase of APA, and essentially the statute, the two-step nature of the Chevron two-step was, first the court would ask, all right, is there any ambiguity or silence from Congress in the statute? And if there was, then they would ask, they defer to the agency, and then they just ask, was the agency, was the agency reasonable in their regulation writing? And generally, if there was that initial statutory ambiguity or silence, they would just defer to the agency. There were very few times that they didn't defer to the agency in sight of that ambiguity, and it was actually So it was like written essentially. Chevron was established. If there is ambiguity or silence in the question or in the statute, they have to defer. It was very deferential, and I'll get into Loper, I guess, in a little bit here, but essentially, okay. It was super deferential. They had to defer if there was ambiguity or silence. Okay. Loper v. Bright, not here. Okay. In a nutshell, what is NEPA? Did I skip a question? Oh yeah, here we go. Yeah. Whoops. So, okay, how did the decision in Loper Bright Enterprises versus Raimondo change the amount of discretion generally afforded to federal agencies by the judiciary? What branch of government does this decision empower? So it eliminates the Chevron doctrine, like we just discussed in the previous previous question. So the courts no longer have to defer if there's ambiguity or silence in the statute. So this is going to reduce the amount of deference given to courts or given to agencies during judicial review. Courts no longer have to defer to an agency if there's ambiguity. In turn, this empowers the judiciary to interpret ambiguity in statutes. And I guess I listened to the oral argument from the Loper Bright case, and it definitely seemed like they talked a lot about the Skidmore deference, and it sounds like that's going to be kind of what, at least from what I could tell, it sounded like that's what they're going to kind of bank and change to, pivot from the Chevron to, which is still, it's not like deferential, not as deferential as Chevron was, and I think it's I need to reread up on it, but it sounded like the agency has to plead their case or be convincing as to how they got the how they wrote those regulations pursuant to that statute. It takes a little more work on the agency's end to get that deference. That's that could be completely wrong. Anyway, okay. So moving on. In a nutshell, what is NEPA scoping? So scoping, as far as I've kind of found some multiple definitions here with this one, but essentially I think it provides an opportunity for the public and agency involvement during the early stages of analysis, and to gather comments, concerns, and ideas from those who have interest in it or may be affected by the proposed action. It's kind of a way of gauging the scale of the action and how the cumulative effects of that action, how far are they going to reach. That's kind of where I've come to with scoping, and it also looks at connected and cumulative actions. How is the principle of precaution to look before you leap integrated into the design of NEPA, and how is it implemented by federal land agencies? Please discuss Section 102 of the law in your answer. So, there was we were talking about the Calvert Cliffs versus the U.S. Atomic Energy Commission in class the other day, and this one, I mean, that kind of really clicked it with me. I kind of had followed it pretty well, but yeah, essentially, in that one, the Supreme Court, the Atomic Commission, they had filled out the EIS, like they had sent it to like some lower level guys, and they did it, but then no one even looked at it, in the higher offices, as far as I remember from the case. So they did the EIS, but they didn't really consider any of the alternatives or anything like that. They still just went ahead full steam with the plan. And then the Supreme Court, when it got taken to court, there was kind of like, hey, this isn't just a joke law you can just brush off. You actually have to, you have to do this EIS, and then you better take a hard look at those alternatives and really consider them, and you got to show that you did that. So that's that's just like, it's the principle of precaution because it forces those agencies to take a hard look and really analyze, what their action is going to do, or the alternative actions, what those would have on. And Section 102 established that. Section 102 is the section that it's the action forcing section of NEPA, and it forces, it sets out, all right, if this is a major federal action, you better be making an EIS. And that EIS is going to analyze, environmental impacts, environmental effects that cannot be avoided, alternatives and their potential effects. And then there's these other two that we haven't really talked much about, but it's like relationship between the local short-term uses of man's environment and the maintenance of enhancement of its long-term productivity, and then irreversible and irretrievable commitments of federal resources which would be involved. But essentially, yeah, like Section 102 really lays out, like, yeah, this is a major federal action. Do the EIS and consider these things. And then the Supreme Court in Calvert Cliffs versus Atomic Energy Commission said, yeah, you better do Section 102, and you better take a hard look at it and really consider that stuff. So, moving on to the next question. All right, why is it said that NEPA is procedural law? What does it have to do with Section 101, Section 102, Section 105, and the role of the courts interpreting NEPA? So NEPA's said to be it is said to be a procedural law because it doesn't require substantive results. As long as an agency does what's required of them, say it's a major federal action, they fill out the EIS and they take a hard look and prove that they really considered these actions, then the courts don't have to enforce the most environmentally. It doesn't enforce the most environmentally sound option. It just promotes that they're informed on the effects of their action. And so Section 101 is, it's really, Section 101 just kind of lays out like what the purpose of NEPA is. It doesn't force any action from the agency or anything like that. It just is, it's very like broad, aspirational, solely provides the purpose and vision and values of NEPA, and that's it's well written, but it doesn't really do anything. It doesn't require anything. Section 102 is like I said in the last one, it's the action forcer. It's if you're going to do if it's a major federal action, you're doing an EIS and you're considering those environmental effects, the unavoidable consequences of those effects and alternatives and their effects. So that's like the biggest. I would say that's it forces that stuff, but it's also if you do that, that's if you do those things to the fullest extent, then you're good. And then there's Section 105, which Section 105 just states that NEPA is supplementary to other authorizations of federal agency. It's supplementary to the Endangered Species Act. So, while NEPA is procedural, it can be used for litigation or it can be used by other in conjoined with other acts to enforce the most environmental preferable action or preferable action based on another act. The role of courts then in interpreting NEPA is just to ensure that NEPA followed, or to ensure that the agency followed the NEPA process. And it's I think here's the quote here. NEPA it says NEPA merely prohibits uninformed rather than unwise agency action. So the role of the courts is just to make sure that the agency is informed, they followed the EIS process, they made the EIS, they considered everything they needed to in there, and they followed the procedure. That's pretty much why procedural. NEPA doesn't force a substantive result. It just is a process that they must undergo and fully consider. What does it mean when people say NEPA is procedural law? Okay, so here's this one again. NEPA is said to be a procedural law because it does not require a substantive result. If an agency properly goes through the NEPA process and completes what they need to, and especially considers the EIS or gets public, goes through the NEPA process properly, then they're not forced to make the most environmentally sound, or there's no forced decision they have to make as long as they've gone through the process. All right, so let's see, here we go. Other statutes may impose substantive environmental obligations on federal agencies, but NEPA merely prohibits uninformed rather than unwise agency action. Man, my mouth gets so dry doing this. Explain what the Supreme Court means by this statement as found in Robertson v. Metho Valley Citizens Council. What does this have to do with Section 105 of NEPA? Does this mean that NEPA is an insignificant law? So essentially, the first part of this is just stating that if an agency follows the NEPA procedure, they're not required to make any certain decisions in regards to environmental considerations. And then kind of moving on, there are other statutes in place to inform those environmentally concerned actions. It's the Endangered Species Act or but I think that's probably a good one, easier one. That the Endangered Species Act will require the agency to do certain things, that they might find in there through the NEPA process. And then Section 105, like I mentioned in the previous one, it states that NEPA is supplemental to those other agency authorizations, like I just mentioned in the previous part about how it's supplemental to the Endangered Species Act, where it will require certain agency actions if there's an endangered species or something present. Okay. And then like I said, it's also EIS does open the agency up to the public too. It makes all this information, everything they're doing, everything they're considering, open to the public, available for public comment. And then after everything's said and done, after the EIS is completed, after they've signed the record of decision, then they're open to litigation as well. People can it can get held up very easily through the EIS NEPA process. And I think, was that all that one? Does this mean that NEPA is an insignificant law? No, absolutely not. NEPA is, like I said, it promotes informed agency decision making, but then also, it's supplemental with those other, other acts in place. And then also, like I just mentioned, as it opens all this information up to the public, and it gets the public very involved. It gets other agencies involved, and it opens up that decision to litigation and provides all that information as well. What is a categorical exclusion as used in the NEPA context? So it's an agency action that's not deemed a major federal action, either individually or cumulatively. And agencies will have these, they do have like preordained or predetermined through legislation. There are things that can be categorically excluded, and as well as executive agencies can make things that are categorical exclusions as well. So it's like I said, it's an act that's found to not have a significant impact on the environment, either individually or cumulatively, and so therefore there's no EIS required. Oftentimes they might need, if they're not preordained, they might need an environmental assessment done first before they can be called a categorical exclusion, just if the full impact's uncertain, or if there's extraordinary circumstances to the situation. What is the categorical exclusion as used in the NEPA context? What are the benefits of using categorical exclusions? Why can the use of categorical exclusions be controversial? Provide an example in your answer. So, like I said in the last one, categorical exclusion is an action that's been individually or cumulatively found not to have a significant impact on the environment. They can be preordained either legislatively or executively by an agency, and so there are some things like, trying to think of an example that we went over in class, maybe like some certain like types of maybe like a campsite maintenance, cleaning of bathrooms, or maybe even like putting in new fire pits and stuff like that. Like that might be category excluded. You might not need to go through the full NEPA process to do that. And then obviously we kind of gone over how the Forest Service has kind of taken that and ran a little bit, gotten a little carried away, and made some stuff outside the bounds of the question. Anyway, they can definitely be beneficial, like I just mentioned, for those routine, small scale projects and things that are, it just wouldn't make sense to spend all this time and resources to find the potential effects of mowing a campground or putting in a new fire ring. There's stuff like that. So they could definitely save time for small scale stuff and routine stuff. Definitely they can be controversial too, though, because I think they really reduce the amount of public involvement in a decision, and we saw this with the Holland Lake lodge expansion. That's the example I got here. It was a categorical exclusion. The people who wanted to develop or update the lodge, they had a huge big plans to add lots of buildings, put in a restaurant, re-update the lodge, a big scale project. But since it was contained on the original lease of 15 acres, and it's a rec site, it was found within so it was predetermined to be a categorical exclusion, and so it was going to avoid having to go through the EIS process, and this led to a huge outcry, and it's dead now. It's no longer going forward, but it was the whole thing was going to be a categorical exclusion from the EIS of NEPA, which, and like I said, it was definitely controversial because it was going to take the public input completely out of the equation. So, describe one real or hypothetical example of how an outside interest might challenge implementation of NEPA as arbitrary capricious as it relates to one of the following issues. And I'm just going to list off the one that I kind of chose with this, as it relates to connected actions. So, I got one last slide for this one. Oh, bugger. Okay. So, here we go. The one I kind of went with is the textbook one, but it was the Thomas versus Peterson, Jersey Jack area, Nez Perce National Forest in Idaho. So it was like I said, textbook definition of a connected action. So in this case, the Forest Service initially comes out with their, they publish that they're going to put in a Forest Service road in the Jersey Jack area. So they conduct an individual environmental assessment for the road, and they find that this road itself has no major significant environmental impacts. Finding of no significant impact, they issue a FONSI, and then following that, they issue separate environmental assessments for 2 timber sales off the road. Now this is my crude design of this. This isn't actually how it was laid out. I'm not too sure, but the timber sales were off the road. The road was for the timber sales. I don't know if this is how they were oriented. It doesn't really matter for the sake of this example. But anyway, so they issue 2 separate EAs for each these individual timber sales, and they find no significant, they issue FONSIs for both of them, no significant impacts. So these are then, they go from the, after getting the FONSI, they technically kind of fall under I guess it's just, record of decision, and that's it. But, so then, this ends up getting taken to court as, people are, challenging this as a connected action. And the CEQ, defines a connected action as, there's 3 things here that they kind of use to define one. First one is, does it automatically trigger other actions, which may require EISs? Cannot or will not proceed unless other actions are taken previously or simultaneously. So, especially with these timber sales here, these wouldn't proceed unless this road had been built. And then number 3, are interdependent parts of a larger action and depend on the larger action for their justification. So in order to justify building this road, they would need to do these timber sales. Now, the Forest Service tried to say that the road would also be used for other recreational opportunities, but then when you go back to the original announcement in the environmental assessment of the road, according to the court document, the road was characterized as a logging road. So, but yeah, so this is kind of so then this went to court, and it was ruled that they needed to do an EIS for this as a connected action. And there was even a 3rd timber sale that they were beginning to prepare an EA for. I don't think they got that far before all this went to court. But yeah, so this could definitely be challenged as arbitrary and capricious as to how the Forest Service would deem this as not a connected action. Okay, so the Bureau of Land Management just released its proposed roadmap for solar energy and development on public lands. I don't know if I want to read the full name of this program, but anyways, they released a programmatic EIS. Programmatic EIS, as well, also known as the West Solar Plan. The announcement says that no solar developments are authorized through this planning effort. Proposed projects will still undergo site-specific environmental review and public comment. So what does this mean, and what does this have to do with tiering? Now, I didn't really read much of that question, but anyways, they've released the programmatic EIS that covers, the broad framework of this solar plan across, the west, southwest. So it covers, like I said, it's very broad right now. The programmatic EIS is very broad. It just covers the overall program, considers cumulative effects, overall objectives, and addresses the broad environmental concerns of the project itself. So then when it comes time to actually put in those actual solar farms at specific sites and locations, then they'll do actual site-specific, area-specific, locale-specific EISs for each of those that really looks at the environmental concerns of just those specific areas. And this focuses on the specific questions and environmental concerns of sites where the action will be taken. So tiering, by preparing that programmatic EIS that covers the broad general environmental concerns of the action, they don't have to be as comprehensive in that stage. They can break things, they can be broad, they can look at overall things, overall impacts. And then, the site-specific, EISs, they'll be, they won't have to address those broad environmental concerns and those broad impacts, cumulative impacts as much, which I think is maybe where it gets a bit tricky, the cumulative impacts. But they don't have to be near as specific at that point, and they can just be more comprehensive and just focus and answer, ask the questions for that individual site. This is an encouraged practice by the CEQ. To avoid repetitive discussions and focus on the actual issues at each level. In theory, I think it would save time too, so they don't have they won't have to spend as much time and resources on those individual site specific EISs, And then the same would kind of go for the broad one, is they wouldn't have to spend as much time and resources going down to the finite details of everywhere where they might think they might be putting in a site specific EIS. So yeah, they can do that programmatic one, and then they'll issue supplemental EISs to go along with it for those specific sites. And that's all I got. Little longer than the last video, but with the last one I was kind of under the gun. I had a little bit of a rush job. I liked having the PowerPoint. I thought that was kind of fun, and it made it a little more engaging, and I liked pointing and pretending like I'm teaching or something. But yeah, I don't know. Like I said, this is pretty much just for myself, but if someone else watched it and they like the PowerPoint, I hope it helps. It kind of helps me, actually. I don't know. It helps me visualize, and then like walking through, especially the connected action one, having the visual, and like I said, I don't know. This is probably not how it was actually laid out, but very broad. This is a very basic interpretation of how that, what went down there of that connected action. So yeah, I'll leave in the description. I'll leave description. Or put the book for the class where I generate a lot of these answers, as well as lecture information about the lecture if you have a yearning to take it. Yeah, I also, a lot of this information too, like I actually got a lot of these answers from those like actual cases too. So if you're interested in any of these, I just recommend looking up the case and reading it, and it's a good way to, I don't know, that's the way I found like learning some of this stuff, or understanding it's maybe a little easier with those examples. But yeah, I think that's pretty much all I got. I'm gonna wrap it up here and move on. So yeah, thanks.